some of you are senior around church. I'm the law firm of Sheffield Loman. I do fiduciary litigation. Here I brought Heidi Eisenhart, one of our partners that does more of the estate planning as well as guardianship litigation. Or not guardianship planning and administration. Now on my side of the litigation, it's when people don't do their estate plans very well. Or there's some sort of typical issues with the family and everything in that regard. So today we're going to talk a little bit about why estate planning, why we need to do it, and how setting up an estate plan can help you plan for the future. So we'll go through a number of different topics. What is estate planning? What benefits does estate planning offer while we're alive? Because sometimes we think estate planning only happens when it's only a will, but it's not. It's far more. Even when you're alive, estate planning can offer protections. What type of documents help us achieve those benefits while you're alive? What type of benefits does estate planning offer after we pass away? What type of documents help us achieve those benefits? Homestead. I'm not sure how many of you own your own homes, but understanding the benefits to homestead for your estate planning as well as for taxes is important, and how to start the process. Now at the end we do have our questionnaire that kind of helps guide you through the process. That questionnaire also describes as a little description of what a power of attorney is, what a will is, what a trust is. So it kind of gives you a little summary that you guys can take home as well.
So you don't have to memorize it.
You don't have to memorize it, yeah. So the first question, of course, is what is estate planning? Now, essentially, it gives your family a guide for either when you're incapacitated or what happens after you pass away. And I know many of you guys are all young, way younger than me. You know, when I first started coming here, I was like, young professionals, I can join that. And everyone was like, like getting out of it. So, especially when I see some of my sanity kids here and young professionals. But anyway, but it's never too early to start planning and start thinking about it. Even how you structure all your assets. So because estate planning is not only how you want your assets to pass, who should get them, but also who should be in charge of the process, whether you were incapacitated or when you pass away. Why do we as Christians need estate planning? I love this verse from Psalm 24:1. The earth is the Lord's and everything in it, the world and all who live in it. Essentially, it's not ours. We may think this is my Tesla, this is my house, this is my 401k, but everything we have is from God, and we're called to be good stewards of it. For those of you who went to the servants meeting yesterday, we talked about stewardship of our talents, but today we're going to talk about a little bit more stewardship of your health, your assets, your family, and your future. Because when God is, in some ways, want to see you a good steward of everything I provided you with, because ultimately it's His. So we're going to set this up a little bit like a question and answer, because I know enough about estate planning to know when you need to do it and when not to do necessarily online. I'll tell you, one of my first cases, I was talking with our potential client. I said, who did the will? Oh, my lawyer did it. Okay, your lawyer did it. Okay. What's the lawyer's name? My lawyer did it. Okay, I understand, but what's the lawyer's name? MyLawyer.com is what it was, and it was very I think it's still a website. So,
and that's why it's in litigation with Kathy.
And that's why it's in litigation with me.
Yeah.
But it's helpful to get good counsel on that, and just understanding the first prong in being a good steward is to know to do your homework, right? You don't necessarily need to sit down tomorrow and do your estate plans, but to understand what's out there, what you need to do. Okay. So the first question, Heidi, is what benefits does estate planning offer while we're alive? Because I said most of the people always think of estate planning as my will, and I'm 25, 30 years old. I don't need to worry about that.
Yeah. Well, I would jump right down just because I'm seeing the room. You're all very young, which is good. It's great. Enjoy that. And when you're talking about decisions for your children, I remember when I was a baby lawyer, I didn't know what I was doing, and I had more debt than any assets. Everybody thinks you have money because you're a lawyer, but you really don't. But so one of the big things was to plan as if I would die, who would care for my child? Who would care for their person? Would my one sister be better at managing property for them and making sure it's invested and they go to a good school and get into college? Would one of my siblings be better at, helping them get to school and get them to the doctor? It doesn't have to be the same person. It can be different people. And then you add a layer onto that. Well, who would be that person if my sister couldn't handle it? Would it be my brother? Would it be my friend? Would it be two people together as kind of a check and balance? So from the very basics is, if you have children and you haven't acquired a lot of assets, okay, that's number one to me. Who takes care of my kids and how do they do it? You can assure the people you select are the ones that you want making the decisions for your person. So that's like your health care and your, what if you're in the hospital? Who's gonna have access to your medical records? Who's gonna be able to talk to the doctors? Is it gonna be only if you can't? Or is it gonna be somebody along with you that you're gonna designate to do it? Because if you don't have somebody named, there's a statute that kind of goes down the list and the hospital can pick. Many times it's not the person you'd want in charge of your healthcare decisions. So it's so much better for you to, while you are not in a crisis, to think these things through and name who you would want to have assist you when you're incapacitated, or assist your children if you're incapacitated or if you pass away. Kathy, did I hit everything there?
Well, I think,
On the person.
Also, it does help reduce potential attorney's fees and costs. You don't want to see me, okay? That bottom line, because litigation ups the cost, right? If you have something in writing which designates what you want, who you want to help with your finances, who you want to help with your children, with your making those healthcare decisions, and you're able to spell it out in writing, also what you would prefer. Because the people that may automatically, as Heidi mentioned, automatically get that authority or have some limited authority may not understand what you feel is right, or they may not even align with what you feel would be the right thing in that circumstance. So it's important to think about those things ahead of time, as Heidi said, before you, so that your family, because if you, God forbid, were somehow to be incapacitated, if you're in a coma in a hospital, your family is not going to be thinking correctly, right? Everyone's going to be emotional and wondering and things like that. So if you've thought about it, you've prayed about it ahead of time to try to get an understanding of what you think is right, it's key to have, and who you would want to make those decisions. And you've potentially been able to speak with those people to at least let them know, listen, are you okay with serving as my power of attorney? Are you okay with being designated to take care of my kids if I become incapacitated? And having that dialogue ahead of time is vital. And it offers a bit of grace for your family too, as I mentioned, whether because they are going to be going through a traumatic time if for some reason you are unable to care for yourself.
And let me add to that, for healthcare reasons, this is interesting. Your healthcare surrogate is not supposed to do what's in your best interest. Did you know that? Your healthcare surrogate is supposed to do what you would want to have done. So if you say, I want to have, this meal, or I want to stay in my home, or I don't want to be moved out of state, they have to comply with it. And so I've actually had, this is kind of funny actually, I've had 2 male clients say who would make end of life decisions for them, their ex-wives. And I said, well, why would you choose the ex-wife? And they said, well, she wouldn't have any problem pulling the plug. She'd be right there to do it. And they really did, because they hadn't remarried, and they thought, well, she'll make the decision I want. There'll be no messing around with it. But really, to have somebody that you trust to make decisions of what you want, because many people, when there's a crisis, everybody comes in, family comes in, and they're all vying for, this is what I think is best, this is what I think is best. No, you put in writing what you want, and then they have to abide by it, and the doctors have to abide by it.
And piggyback on that, the I think is best going back and forth. There's a lot of stress in your family. You don't want to cause strife in your family. You know, hopefully everyone's family gets along, but in those circumstances where one person says, this is what Kathy needs, you know, this is what Kathy needs, if you set it down in writing, and you've had that thoughtful discussion, it reduces the amount of stress for your family as well. And then turning toward your property. So that's more of the questions about your healthcare, and we'll go into what documents you need for that, but for your person, but also for your property. So what happens, how can I designate, or what protections does estate planning offer for my property?
Oh,
if I'm alive.
If you're alive, yes. You can name a durable power of attorney, and that's somebody that even if you become incapacitated, they can make decisions for you, financial decisions. It can be as broad or as limited as you want. They can make decisions regarding selling real estate, making gifts, paying for your bills. I usually think of this as if I were, let's say my husband and I were in the hospital, and we couldn't act for each other, our successor power of attorney could come in, make sure the mortgage is paid, make sure things are done, contact health insurance companies, do those kinds of things that are property related. But this is the big one, you have to trust the person you name. Because when they have that power, and if they have that original document, they could go to every bank in town and drain the money. So, you know, good lawyers will say, okay, do you trust them with everything? They're not gonna go to Las Vegas, right? They don't have a manipulative spouse who's gonna say, it's yours now, you take it, you know. So you wanna be, and that's what a good lawyer's gonna do, is really push you to think about those things and ask about relationships that you may not have thought about. Because we see bad things, you know? So we try to prevent that, which is, it's kind of a gift. As my dad would always say, never underestimate the power of a bad example. So we've seen plenty of bad examples, and we don't want them to happen to any of you or any of our clients.
Well, Heidi, is it, with the power of attorney only act when you become incapacitated?
No, it's valid as soon as you sign it, but you don't have to give it to them right away, okay? You can put it in a drawer and say, okay, if something happens, if there's an emergency, this is where you go to get it. Because also you may change your mind. Maybe that person, you don't want powers of attorney floating around. You know, we in our office do a duplicate power of attorney, so we have an original in our vault file to release in case of an emergency as well. So.
And also it can apply too, if for some reason you're not incapacitated. Say you have to go to Egypt for the summer, right? And you have to have and there's your pipes burst in your house, and somebody needs to get the plumber out there, and somebody needs to contract for. And nowadays you can call on the phone, but it's difficult, right? It's particularly getting any money to them and everything of that sort. You can call up your power of attorney in that instance. You can make directions, and you can help facilitate an easier management of your assets when you're not physically here, or there's certain impediments that would restrict your ability to do things with ease.
Yeah, that's a great point, because it doesn't have to be if you become incapacitated or an emergency or crisis. It can be if you're out of town for a long time, and then you know you have some peace of mind that somebody's gonna step into your shoes and do what they are supposed to do.
What about credit and asset protection for your property while you're alive?
Yeah, a power of attorney can structure things for your benefit if they need to. Basic creditor and asset protection that you have is how you title accounts if you're married. There's certain ways, let me give you just an example that's kind of real world here. Let's say husband and wife, you each own a car. How many think you should have both cars in your joint names? Okay? How many think you should have one car in the driver's name and one car in the other driver's name? Okay, there you go. This is a big question, because if you're husband and wife, you have all these creditor protections. So you want to have the car that your husband drives most in his name, the car that you drive most in your name, because if you get in an accident, it's the owner and the driver who gets sued. So let's say you're letting your niece drive your car, it's your car, they can't get to you, if they sue you, they can't get to you and your husband's assets because it's protected as tenants by the entirety, it's called, under the law. So just thinking through, having an attorney to think through, oh my goodness, this creditor issue, you know, we need to try to confront that or prevent a problem down the road. That's important. There's homestead protection that you have with your property. We're gonna go over that a little bit later. You know, you provide the ability to direct how someone should use assets. And I've seen powers of attorney that are really broad because they trust them and you never know what's gonna come up in life. Life's uncertain, right? And I've seen powers of attorney that are very limited. They can sell my house and pay these bills. That's it, you know? So if an attorney puts a 30-page power of attorney in front of you, you know, you wanna read it because those are the powers that you would be essentially giving the person you trust in case you couldn't manage those things for yourself.
And we went over a little bit of these, but just to understand which kind of documents apply to your person and property while you're alive. And we went over healthcare surrogate, so what can a healthcare surrogate do for you?
Okay. You've probably been to the doctor's office or hospital and they hand you a healthcare surrogate, living will, and they'll tell you to fill it out, those types of things. A healthcare surrogate is someone you name if you cannot provide informed consent to make decisions. So if two doctors say, we can't rely on your decisions, that's the person that steps in and manages. That's the kind of healthcare surrogate that are usually at the hospitals. The law changed a few years ago, so the documents we use allow you to name somebody to make medical decisions with you, so there's no delay in treatment, or it allows them to get access to medical records later if they need them, or now along with you. So there's a lot of different combinations that you can have when you name somebody. Do you want them to have access to medical records? Maybe not now. Maybe that's only if you become incapacitated. But do you want them to help you make decisions and go into the doctor's office with you? Maybe. So that's what a healthcare surrogate does. That's different than a living will. Living will says if you are in the end stage conditions of life, do you want to have life support withheld or withdrawn? Now that's different than a do not resuscitate order, okay? Do not resuscitate order, you guys are too young for a do not resuscitate order, okay? If I choke on a chicken bone and I can't breathe, by golly, I wanna be resuscitated, okay? Now, if I'm 90 years old and I'm already in poor health, do I want my bones broken or do I wanna go through trauma? Maybe not, maybe I wanna do not resuscitate order. But people often confuse a living will and a do not resuscitate order. So for each of you, I would consider a living will of how you would want things to be managed. Would you want food or water withheld? Who would you want to, in what stage of end life would you want things withdrawn? You can be very specific. Some people say, I don't want blood transfusions, and they'll put that in the document. So we really tailor make those to what your wishes are. Because again, if you recall, your person in charge of your healthcare decisions has to do what you want. So that's what we try to do, is make your wishes known to the doctor, to your family, to everybody involved.
And I will pause here, because one of the reasons when I talked with Abuna, I heard people say, well, I need an estate plan. I need an estate plan. What do I do? I talked with Abuna, I said, I was directing the older people, the ones that were 90 and thinking the tunts and the gidus and things like that, okay? And then, but Abuna said, no, you can't start there. Better to talk with you all, and then you can kind of have that understanding for your own estate planning, but also to talk with your family members, to talk with your parents, to talk with even your grandparents if they don't have anything, because apparently it's very different, and I didn't realize this. All this stuff is very different than in Egypt. And you all have to have a good understanding of what's happening, because it may be a difficult time to sit your parents down and tell them they need a will, or they need a trust, or they need a pre-need guardian. A lot of these things too, if you guys are gonna maybe potentially the caretakers in a few years of your parents as they get older, having a frank discussion with them now and trying to talk with them about why this will help you, for you to understand, is sometimes the dual purpose of today as well. It's one thing you guys plan for your kids, you guys plan for your assets, but it's also you to be educated enough so that you can hopefully get your parents thinking about some of these things and get a dialogue in order, because they may be scared, or they may be thinking about, I didn't realize, but Luna said in Egypt, the government takes your money, I guess, and then you have to get it from the government. That's not what happens here. But it's, so of some of these things, you may think, well, I'm not gonna need a living will, I don't need to work, or I don't need a healthcare surrogate now, I'm in perfect health. We never know. We don't know what tomorrow brings, right? But secondly, you're gonna be interacting with this with other people in your family and things like that. It's helpful to have this foundation.
No, that's great.
So, and then, going through the designated preneed guardian, what is that, Heidi?
That's if you say, if I ever need a guardian appointed by the court, if I am in a coma, if I am completely mentally incapacitated, I'm wandering around, I need to have somebody appointed for my person and property. Who would I want that to be? And it usually mirrors who you'd want as your power of attorney for finances and who you'd want for your healthcare decisions. But it's that extra little placeholder. So if some crazy family member tries to, and we've seen it, tries to go into court and say, I want to be in charge. Oh, no, I already have a document that says who I would want to be in charge. So that's what that document is.
Thanks. So turning to the property, we talked a little bit about a durable power of attorney.
Count titling?
Count titling, yeah. How can that be a form of estate planning?
Yeah. Estate planning, if joint accounts, there's a presumption under Florida law. If you have a joint account with another person, that you intend if you die, it goes to the other person. Now,
Likewise, throughout your life, they can take that money out. Sometimes people put someone on their account just in a joint ownership, thinking they're just looking out for me. They'll pay my bills if I need it. But technically, that person can is considered a joint owner of that account. So they could drain the entire account without you even knowing it.
So there's a lot of risks. Or maybe they're the best, that's your daughter or something, and they're the best person in the world. Well, what if she gets in an accident and gets sued? Those funds could be at risk. So part of estate planning is to say, okay, rather than doing these joint accounts, unless you're husband and wife, that's a different thing, because we have special protections for husbands and wives. If you're doing joint accounts, have the person on as a power of attorney. Don't have them on as an owner. Or have it be payable on death to your beneficiaries, but don't have them on as an owner where they could be at risk from, for their creditors, or they could take the money, or there could be an attack situation. So we try to discourage joint accounts unless they're husbands and wives.
Now, revocable living trust, like I've heard a lot of people ask, oh, I need a trust, As a trust protects everything. So tell us what a revocable living trust is.
Yeah, a revocable living trust can avoid guardianship during your life. It's a separate entity. It's kind of like, a trust is like if you have a corporation and you're the president of the corporation, okay? And the vice president's sitting there, well, the president gets sick, the vice president comes in, steps in, manage the assets in the corporation. He can only manage what's in there, right? So a trust is an entity that you put assets into to manage. You're the trustee while you're living, you're in control, but if two doctors say you can't manage, then it has a successor trustee that just steps in. No court involvement. The trust is a separate document. It is confidential. It's never filed on the public record. So there's some confidentiality there. And it's just a separate entity to hold your property and to talk about, where it goes after you pass away, or how it should be used during your life.
So let's talk about when you pass away. So what benefits do estate planning documents offer after you pass away? First of all, as the person.
Yeah, okay. Yeah, for funeral wishes. Some people have very specific wishes, not just for if they want to be buried or where they want to be buried, for instance, but how they want the service to go. Who do they want to have speak at the service? Those types of issues. I had one that wanted a white carriage with horses and a white buggy, and to put the casket and drive it through town. I mean, people have some really specific rules as to how they want things to go. I had one guy that actually said he wanted cremains put in fireworks, because he found a company that would do that. I doubt it would be legal, but anyway, you hear all kinds of stuff. So putting those in your documents gives kind of, that break where everybody's coming in saying what you would have wanted. No, it's there. Here's what I want, and maybe it's something very simple. Or maybe I just want this person to be the point person for all this. So however you want to handle it. You can do organ donations. You can have a declaration of those. Some people give their bodies to medical science. There's different things that have to be set up. Most organ donations, it's on your driver's license if you want to give organs, but there's also a separate declaration.
Most of the estate planning though is with property, isn't it? I mean.
Yeah.
So what kind of estate planning benefits, what kind of benefits are there for estate planning after you pass away as your property?
Oh my goodness. Well, first of all, who's in control? Who's gonna pass out the property? Who's gonna gather assets, pay any creditors, taxes, and get assets to the beneficiaries as they should go? Okay, so who would that be? Let's say you name your spouse, but then you think, okay, what if your spouse can't act? Who would be second in line after your spouse? Now the rules are, for a trust, it can be anyone. But if you wanna do a will, and you name something called a personal representative, in some states they call that an executor or executrix. If they're related to you, they can live anywhere. If they're not related to you, they have to be Florida residents. And they can't have a felony. So I would doubt that many of you would want to pick a felon to manage your estates, but sometimes you don't know things about people.
But if you have a best friend from college and they live in New York City, they can't do it. I mean, unless they're gonna move far for a while, but,
Exactly.
What about tax planning and your estate planning documents?
Yeah, there's federal estate taxes, and many people, aren't in the $14 million range each. It's actually $13.99 million each, about $28 million per couple. But in 2026, it's called the sundowning section. The rates for federal taxes, they go back to the 2017 amount, which is a lot lower. So that's $7 million, okay, for each person, and $14 million for each couple. You may think, oh, I'm never gonna have $7 million. Why am I worried about that? Well, what if you get an inheritance that's significant? What if there's a lot of life insurance that pushes your estate amount up over? So a lot of attorneys right now are getting kind of nervous to see if Congress is gonna extend this federal estate tax deadline, or if it's just gonna go back to 7 million from 13.99 million. Anyway, that's probably not most of your worries now, but it is out there and people often ask about it when they come to me.
How about directing how your assets will go when you pass?
Yeah, you want to, like, for instance, if you have tangible personal property, okay, if you have things, let's say jewelry, car, paintings, anything you can touch, not cash, you can designate in a separate writing, as long as it's referenced in your documents, who you would want to have those things. So maybe it's, a friend from church, you want to have a bracelet, or 2 nieces, you promise this one this, you promise this one that, any kind of thing. And that's nice, because all you have to do is sign and date it. You don't have to come back to us to revise your documents. You can tear up that list and do a new one, you just sign and date. So that's, sometimes those little things and those mementos in the family, they may not be valuable to the outside world, but those are the things where you get the fights. So being able to designate that in your own handwriting is definitely helpful.
But Heidi, if you don't have a will, say.
Yeah.
If you don't have a will, where do your assets pass to?
Well, if you don't have a will, the state of Florida writes a will for you. So how kind of them, right? So there's a statutory will, and it may not be the will you want. It generally tracks how most people's wills go. Like, it goes to your spouse. Your spouse is not living to your kids. If your kids are not living to their kids, it kind of goes down the line. But again, it's pretty bare, and many times people don't want. When I meet with them about their estate planning and I talk about how it would go versus how they want it to go, it's a little different.
And if you don't have kids and you're not married or anything like that, who does it go to then?
Well, then it goes down the line to, like, your parents, your cousins, it spreads out. So it's hard. Kathy, that's a good point, because one of the big questions I hear is, okay, I don't want the state to get my assets. If I don't have a will, it's all gonna go to the state. That's not true. It takes a long time for it to escheat to the state. I mean, it has to go through your whole family. It's called lineal consanguinity, anyone who would be related to you. So don't worry about that. Before it would take a lot for it to get to the state.
But it may not go to the people that you think should go to it. Or if you have a will or a trust, for example, say if your assets would go to your brother, and you know your brother struggles with alcoholism or gambling or something of that sort. You don't want to enable him, right? That wouldn't be a good steward. So if you set up a structure, whether it be a will or a trust, you can maybe still give it to your brother, but have a trustee
Manage it.
controlling how the assets go to him or likewise with your children. You could, if assets would go to your children, maybe under the state-made will, under intestacy, but maybe you don't want to give them a check when they're 18. You want them to show, they have to finish college, or when they get married, they get this, or different levels.
Or if there's a special needs child or beneficiary in your family, you don't want them to get a pot of money. You'd want it to have it go into a special needs trust to allow them to get their government benefits for their life. So there's all types of combinations, like Kathy was saying. Sometimes if a family has somebody who has a drug problem, they have to pass so many consecutive drug tests for them to be able to get a distribution. I mean, really it's sky's the limit of how you want to make your estate plan work depending on your unique circumstances. Because it's not just, it's not just about you, right? It's about, would an 18-year-old person do well with $25,000? Probably not, not most, but like Kathy's saying, that may not be a blessing to them. Having some guardrails and how you set it up can be helpful.
And finally, one of the benefits for the estate plan is like when you pass away, like when you're alive, is setting out a good estate plan, a thorough estate plan that addresses these what ifs, avoids you having to see me, avoids you having to have litigation costs and additional, potentially you could avoid probate and avoid the cost associated with probate as well.
Yep.
I had a question.
Sure.
Are these estates like multi-generational? Like, so for example, like my parents make them an estate, and then I'll make an estate for myself, like, and for my future kids. Is it like where, like, my parents' estate can go to their grandchildren type thing, or is it like we have to have two separate estates?
Generally, you have to have two separate estates. But let's say you established a freestanding trust for one of your children. You could have your parents give a distribution to that trust. So you could kind of combine, but generally each person has their own estate plan.
But your parents could give to your kids in their estate plan.
Oh.
They could say, well, my son has enough assets. I'm gonna skip that generation and I'm gonna go to my grandkids. And they could set it up that way, if that's what you're asking. But each person needs their own estate plan. Sometimes people set up a family trust, a family trust, and then other people may contribute to that family trust. But that makes it a little more complicated because then you have different people expectation. You have to make sure everyone's on the same page, I guess.
Yeah. So, sometimes we work with, like, if you came in and said, I need an estate plan, but my parents are thinking about this, we can think about how to kind of consolidate portions of it so it would flow through, but it doesn't need to.
And likewise, and you can make different trusts for different purposes.
Mm-hmm.
Like if you want a trust of money to give to the church or to a charitable organization, and you just want those monies to go to a charitable organization, can't you make a trust just for that purpose?
Mm-hmm.
So it could be where you can kind of outfit it there's a lot of different alternatives that you could have. So let's talk a little bit about what documents prepare. We talked about the last will and testament. What does that apply to? Is everything passed through a will?
No, only things, if I pass away, okay, and my house is in joint names with my husband, goes to him, right, by operation of law, joint, okay. If I have life insurance and Kathy and I are close, and I named you as beneficiary of my life insurance, that goes out to you. And if I have a separate writing list and I name my children to get certain things, that goes out to them, okay? Doesn't have to do anything with the will. But what if there's an account out there that I forgot to name a beneficiary on, or I didn't have a joint owner on, or I inherited and it's just in my name?
Or what if you have litigation? Like what if
Or litigation.
it was a car crash that caused Heidi to pass away, and there's litigation relating to somebody else is responsible for her death? That also would go through the
Probate.
probate.
Because then you'd have to get a personal representative appointed to either continue the litigation, step in my shoes, because I'm not alive to do it, continue the litigation, or step in my shoes and make sure that account that's not titled properly gets to the right people. Because I'm not there to sign a deed anymore. So the person I name in my will is the one taking on that charge and doing it according to law.
And then ultimately, say the account is $500,000 and ultimately that account passes as per the will. So whoever she designated. So it's important, it's kind of, you know, I always, when people ask me, I would say that the will may not take effect, but you always want to have one in case. Because there's always the potential for something else out there.
Absolutely, you always wanna have one.
And
And
then
the will's usually where you name the pre-need guardians for your kids. That's where you put that in there. You put your funeral arrangements if you have them in your will. So that's important.
we
Okay.
talked a little bit about revocable living trusts before.
Mhm.
So transfer on death designations.
Yeah, that's anything you can name a beneficiary, like life insurance, a 401k. They call it transfer on death, payable on death, in trust for, anything where you can name a beneficiary that passes outside of the will. So what gets confusing for people is when you consider an estate plan, you gotta consider everything, right? Because I'll have a mother come in and she would have had maybe a local daughter on her account. She has 2 other kids. Because her daughter was great, her daughter took care of her, blah, blah, blah. But her will said, it goes to my 3 kids equally. Well, the other 2 kids come along and they say, hey, that account where my sister's on, she needs to divide that between us too. That's what the will says. And the sister on the account suddenly says, mom wanted me to have that. That's what mom wanted me to have. So if you're looking at just what your will says, it may not match unless we're sure that all of your beneficiary designations, transfer on death designations, joint accounts, we gotta look at the titling of those things. So it's all consistent with what you want. Because the point is, this is about what you want. This is about how you would want things to go. So that's our job, is to explain the idiosyncrasies of the law and get there. Okay.
What about, so jointly held property, we talked a little bit about that before.
That's if you hold property with another, and there's that presumption that you intend it to go to the other person. That's like, for instance, easiest, a house, right? Or a bank account, you intend it to go to that person upon your passing.
And then what's an enhanced life estate deed?
Enhanced life estate deed is also known as a ladybird deed, okay? And this is a neat planning tool that couples use a lot, because it allows them, it kind of is like putting a beneficiary designation on your deed, is what it's like. So let's say, Kathy, you and I have a deed together, and we can live in this property, we've been friends a long time, joint, we're here together. Well, and we want a friend to be on as a beneficiary, okay, at our deaths. Right now, the deed would read, Kathy and Heidi. If Kathy dies, it goes to Heidi, Heidi dies, it goes to Kathy, okay? This would allow you to say, Kathy and Heidi, deed it to yourselves for life. For your lives, you can do whatever you want with it. You can still transfer it, sell it, use it, mortgage it, rent it, but it has a little plus. At your deaths, it goes to your friend, and that's on the deed itself. So then if something happens to both of us, our friend would just need our death certificates and file them on the public record, and the house would be theirs. So without going through a big administration, it kind of allows you to just add someone on as a beneficiary.
And I think it's a lot of times it avoids probate, like when Heidi did my parents' estate planning shortly before my mom passed. They owned everything jointly. After my mom passed, my dad's the house they jointly own goes to my dad, right? We didn't need any probate, anything going on. But, you know, if he should pass, we're gonna have to open a probate just for the house. And likewise he has, but with an enhanced life estate deed, what I've been trying to tell him, listen, Dad, meet with Heidi again.
I'll talk
before you, yeah, meet with Heidi again, because it would be better, everything's going to my brother and I anyway. It'd be better, you have an enhanced life estate deed, everything goes to my brother Nick and I, and that way, we don't have to worry about a probate. We don't have to worry about creditors, we don't have to worry about any of that. So those are key, and he also has a, if he has a house in another state, a lot of states don't do it that way, so Florida has a unique advantage in that way. If my dad wants to sell his house, he doesn't need to call Nick and I up on the phone. If it were just a straight life estate deed, he would have to get the title company, everyone wants our permission first. And we may have to come here and sign documents, just much more of a hassle and a burden, right? But with enhanced life estate deed, he's free to do whatever he wants. But if anything should happen to him, God forbid, it goes to my brother and I without having to worry to go through probate.
And it's not a gift. It doesn't cause gift tax problems. It doesn't, am I reading your mind?
Yeah.
Okay, it doesn't, because it's not, you're gifting it to yourselves and then putting a beneficiary on there. So you're not giving up any interest, which is kind of the beauty of it. And it doesn't hurt, it wouldn't hurt Kathy and I if we needed Medicaid or government benefits, and it wouldn't be a tax issue, and it shouldn't be a problem with the mortgage company because you're not conveying any interest. So if you have a mortgage, you're just giving it back to yourself. So it's not a problem.
But also, doesn't it avoid the step up, like the basis, so you don't have to pay a lot of capital gains money?
Yeah, they get a step up in basis, but just to that point, and what we're gonna talk about next in Homestead, I think, coming out, yep, is Homestead, and I'll get to that right now, because the Homestead is a pretty cool thing in Florida, okay? There's really three main buckets when you think about Homestead, okay? You think about the tax break you get on your home, right? You get the tax break, I think it's up to the first $25,000 of your value, your assessed value on your home, if it's your home where you live and all of that. It's also not disqualifying if you ever needed any kind of government benefits or support. They don't count the homestead against you. People say the government's gonna take my home. No, they won't. It's exempt, so it won't count against you there. There's some major creditor protections with homestead. Homesteads you cannot force a sale of a homestead to pay for creditors. Now that's a little different, a few exceptions if you have like tax liens, or if you are going through a mortgage foreclosure because that's attached to the home, or it's like a special kind of lien attached. But what I'm saying is, if a credit card company sues you, they cannot make you sell the home to pay the debt, which is kind of nice. So a lot of people put their money in homestead. Now the big one under Florida law is, this is why O.J. Simpson, he had the trial against him. California, I don't know if you guys are old enough to remember that. Gosh. Anyway, he buys a big home in Florida, right? People in New York, no offense to people up in New Jersey, New York, but you know, right before they file bankruptcy, they'll dump $1 million in a Florida homestead and then retire to Florida. That's because Florida has something under its constitution. It's called the Constitutional Protection Against Creditors' Claims at Death. So as long as my home goes to a relative, not a friend, as long as I don't direct it to be sold in the will, I just leave it, it passes. If I have $1 million in credit card debt or Medicaid claims, it passes free of creditor claims to my heirs. They do not have to sell the home to pay for creditors. It also gives them what you were referring to as a step up in basis. So let's look at the difference. What if I said, oh, I'm about to die. I'm gonna sell my homestead and give the money to my kids right before I die. That would be a bad idea, because then you would have this huge gain property tax wise from when you bought the homestead to when you sold it, okay? If you wait and you let the property pass to your children, the date of death basis is what they get. So there's no tax gain on the property. So they get it and there's no, huge tax bill that they would have to pay. So there are a lot of benefits to having a homestead in Florida, and a lot of reasons why, you know, people will put a lot of money into their home for asset protection and whatnot.
And for your age group, I've heard people raise those concerns. Well, my dad, you know, bought a home in Miami when it was $100,000, and now, 30 years ago, and now the home is up to $1 million or more than that, right? I don't want that house because I can't afford the taxes, or I can't afford the capital gains taxes on that house. But if it's your parents' homestead and they're giving it to you or they're to relatives, there is that step up in basis. So that's another, have a discussion with your parents, like pin that one, remember? You can try to talk with them about it, because they may not want to address it right now, I think.
Well, and sometimes it's kind of easier because, you know, like, you're always gonna be the child to your parents. You're never the parent to your parent. I don't care how old or incapacitated they become, right? You're always gonna be the child. So sometimes it's easier to say, you know, I heard somebody speak at the church, you may wanna go talk to them, than try to convince them, you know? Because, again, you're the kid, what do you know, right? Sometimes they'll listen to you and sometimes they won't.
So how do you designate property as homestead?
Okay, you get it, you go to the property appraiser website, it has to be designated before, you have to be living in it January 1st of each year, it has to be designated before March 1st
So
of
if you
each year.
bought a home, make sure you do that, right? Okay, and so for your
Yeah.
tax, because it's also the property taxes, obviously you get reductions in that, and, as well as for the estate planning purposes.
Well, and that's for the property taxes.
Right.
The creditor protection is under the Constitution, it's a little bit different, but it'll have the same effect, so we're good. Let's see.
What is the effect of such a thing during your life? I think we talked about that.
Mhm.
What is the effect of such a thing after your dog passed away and the creditor protections?
Yeah, I think we're pretty good. Homestead, very cool in Florida. Other people don't have this, the
That's why
benefit.
more and more people just move to Florida, unfortunately, and then we have to expand I-4 again.
But keep in mind, if I said in my will, my homestead shall be sold and given to my child, that would take it out and it would be subject to claims of creditors. But if I say, my homestead shall be left to my child, that's why getting wills online, trying to get somebody who kinda does it, those few words can really mess things up for your estate planning. You know, and a lot of lawyers, if they don't do estate planning, they don't know how damaging those words can be. So even if somebody brings a will from another state, I always look and make sure, okay, you may not need to update it, but I don't want it to have specific language that's gonna hurt homestead protection in Florida. Okay, sorry Kathy, go ahead.
So the last thing is, how do we start the process? What do you guys need to start thinking about for your own estate plan? And I think the first thing is, well, Heidi kind of suggested before, you need to know what you have and how your assets are titled. And ideally you have that written down all in one place, because all of this estate plan, if you're not sure how it's titled, if you don't know where the assets are, if you don't know if you have beneficiaries, that's the first step you need to kind of do your homework on.
And in a crisis, you need to know it anyway, right? So even if you're not looking at it for estate planning, put down, okay, I have a joint account at this bank with this person, my life insurance is these people. You know, those times go by when you designated something in a job and then you forget who you designated. You know, keep kind of a book, so then if somebody does have to pick up for you, they have something to work with and they don't have to try to find all that find out all that information in a crisis.
And it's hard to find out. I have one case where mother died in 2018, and it's 2025 now. We just found, oh, there's another account that she didn't realize, she didn't know about, and it was on, and so, when we talked with Merrill Lynch, they said, well, it's a good thing you called, because this would have gone to unclaimed property if you hadn't claimed it within a certain amount of time. So, I don't know if you all have looked under the unclaimed property website, but it's one of the first things I think your team does once someone passes away, is Florida, sometimes banks, and they have,
After 5 years.
after 5 years, yeah, it goes to the Department of Revenue, and they hold it as unclaimed property. I have another case where the trustee, $1 million in assets is an unclaimed property in the state of Georgia, because the trustee did not, he was co-trustee, and his brother did not do anything after the first brother passed away, and it just went to unclaimed property. So, but not all that being said, I just, looked on there, and I got like $50. Wow, I didn't even know. So
It's a Florida
put your name in,
website.
put your name in, check.
Yeah.
You could have a nice dinner during the Holy 50.
It's a Florida, you know, it's also called the Florida treasure chest. So yeah, put your name in or your relatives. Who knows? Okay, so I think, you know, knowing what you have and how your assets are titled, knowing who your heirs are, and you think about beneficiaries, and if you have any charitable beneficiaries. We try to do all the what ifs, you know, okay, if this person isn't living, then do you want it to go to your children? Or then do you want it to go to your children's children if they have children? What if they don't have children? Then where do you want it to go? So we don't want you to have to come and update your documents all the time. We try to make them as fluid and flexible as possible, so then you have all the what ifs taken care of.
And understanding what's the difference between heirs and beneficiaries, Heidi?
Oh yeah, heirs would be who Florida thinks your heirs are under the statute when they write a will for you. You know, your kids, your parents, your brothers and sisters. Beneficiaries are who you want to name. And maybe you want to name some of your family and not all of them. You know, those are your beneficiaries.
Or maybe you want to name a lifelong friend that you've been friends with since you were 5 years old, and you wanted to give them something. That could be a beneficiary that wouldn't be considered an heir. Knowing who you would want to manage your assets both during your life and at death. And understanding the first thing is who do you trust? Who do you trust not to deplete the account and run away to Hawaii, but also who can do it? You know, you may trust your mom for everything, or your dad for everything, but if they're not the best, understanding what's going on financially, they may not be the best person to select them. Or if they're getting older and you're wondering if 10 years from now, they're going to be able to understand as well, you know? So this is something where you really need to pray about and think about and evaluate and predict. And
it could be like your mom and your sibling together. So as your mom gets older, maybe she needs a little help, but you still think she'd be the best person. So it doesn't have to be just one or another. It can be more than one person.
And you can choose. Sometimes I've seen where people choose like their spouse, but their spouse has to act with a CPA or someone professional. Maybe, like, especially for these larger estates, maybe they think, I want to give my spouse that decision making, but he or she doesn't necessarily know the ins and outs of this. So they of course, if you name someone professional, that person's going to want to be paid. So that's the downside of naming a professional. And trustee, if you name a professional trustee, very often people say, well, I'm going to name Bank of America as my trustee. Bank of America only will serve as trustee for very large estates, and they'll charge a lot of money. So keep in mind, you can put someone professional on there, but you want to think about who that would be and who you can trust, but also who has the skill set to be able to do it.
And you can say a professional individual. So it can be like a family friend, CPA, or somebody like that. You can even put in your documents how much you think they should be paid to do it and have them agree to it. So instead of being thrown into, like Kathy said, a bank situation where their minimum's probably going to be $2 million or something for a trust.
Okay, knowing who you want to make decisions you concern your on-care and care needs.
Mm-hmm.
We talked about that before. Who you would choose as your healthcare surrogate. Likewise, who was you trust, but also who would be willing to do it. If your mom is going to be emotional and not going to feed them as much feed through the tube as possible, give them more, and it's not anything a medical doctor says, right? Then maybe your mom's not the best person. Maybe so it's considering what that person could be the best, whether the best person for it, both on a trust level and also.
And I'll give you a personal. This is a very real example to me. Okay, I have a daughter and she's 31, and I have a son and he's 19. And so I do the elder law stuff. So I don't really want to be in a facility, right? So I'm already trying to kind of brainwash my kids. I encourage you to do the same with like a Socratic method. Luke, so tell me, son, what if mom gets really old and she needs to be somewhere? Where do I want to be? Home. You want to be home, Mom? Yes, I want to be home. Now, what do I want to be doing at home? You want to sit outside and feed the birds and do, gardening. Yep, that's what I want to do. Okay, good job, Luke. What if your sister tells you that I should be in a facility? I'm going to tell her no, Mom. And I said, okay, good. So anyway, we're starting young.
When he was 5, she started.
I did. So you ask him now, Johnny on the spot, he's got the answers. So, never too young to indoctrinate your children with your healthcare wishes. So.
And finally, and we talked about this before, designating alternatives, because there's always a bunch of what ifs, and it's important to have in those dates, in your estate planning, not only alternative for beneficiary, alternative who's in charge, but also the alternatives for the beneficiaries as well.
Okay, I think that's it.
Any questions? Sorry, we went a little over, I guess.
Thank you.
Sure.
Okay, great, and then we have, like I said,
He has a question. Yeah.
So you guys talked about revocable trusts a
Uh-huh.
lot. What's the difference between revocable and irrevocable trusts?
An irrevocable trust is something that you set up where you can have no incidence of ownership. So you put a bucket of money in a trust that you can't touch, that somebody else manages. Yeah. Now, a revocable trust is revocable during your life, but at death it becomes irrevocable.
Because only you can change it.
Okay.
So when you pass away, after you pass away, it can't be changed.
Okay. All right. Thank you.
Anybody? Yeah?
I just have a question in terms of like children with disabilities.
Yeah.
So I have a sister, she's an adult, she's 22, and she's disabled. Even though she can speak a little bit, but my mom is really kind of in charge of everything. However, my mom's not from America, so she doesn't know how anything works here. And I'm learning everything to try to pass on to her. So in terms of my sister and her assets and everything like that, how would she be able to have stability, or what would she have to do in order, I don't know.
Right. No, is your sister's local?
Yeah, I live with her, yeah.
Oh, okay. Is your sister would she be competent to sign documents, or probably not? Okay, well, there's a couple things. First, if you're looking, you need to talk to your mom about inheritance, because for your sister, if she needed, and she probably may be on them, but if she ever needed government benefits, you would want it to go into a special needs trust for her for lifetime. So that money in there does not supplant what the government provides, it only supplements. So that protects it, so it can be used for extra things. And then your mom could say at her passing, then it goes to you. So you want your mom to do that planning now. You also may want to think of a guardian advocacy or something for your sister, so you have legal authority to make health decisions. And we do those all the time. Is she developmentally disabled since birth?
Yes.
Okay, there's a shortened form of guardianship, not the one that Kathy was talking about here, but specifically for people who have family members who are developmentally disabled. And then your mom could be the guardian advocate, and then name you as the successor, so there's no delay, and you can just step in and manage.
Because like I said, the risk comes with the delay in filing it. And your mom may be able to handle everything right now, but what if she can't all of a sudden? And then you have to file things with the court and wait for a court date and everything of that sort. So it's good to be thinking about now. Sorry, was there another?
Another question. Is there an annual fee to maintain a trust, as there would be for something like an LLC, where there's an annual fee for the estate?
No, there's not an annual fee to main. Are you talking about if you just set up your own trust?
No.
Or if,
No, like
bank?
once it's set up, right?
Yeah, if we
Once
have
it, like once you guys help
formally
do
set up.
it.
No,
do
no,
it.
no, no.
No,
Okay.
it's your trust, there's no annual fee to maintain it from like an attorney's side or anything like that.
And yeah, they just say plan, you make it and you go home with it, and then you may come back in 10 years and say, all of a sudden I have these kids and I need to figure out something for them. And then
All right,
revise
I won
it.
the lottery, what do I do?
Yeah.
When
Yeah.
you make the trust, does everything automatically get put in it, or you have to
That's a good question.
transfer the deed into the trust for the house? You have to transfer your 401k into now this trust.
Well, we help you do that because there's certain tax ramifications in doing that. So many times, remember how I said homestead is exempt from creditors' claims and it's under our Florida Constitution? Okay. A lot of people say, well, I want to put my homestead, I want to deed my homestead into the trust. Well, the most conservative thing is to not do that, because we're always afraid as attorneys of a case coming up where a creditor says, wait, that homestead can be used for creditors' claims now because the trust isn't a natural person under the Constitution. That's who gets the protections. So some people do put their homestead in their trust as long as they know the risk. And some people just leave it out or do an enhanced life estate deed. As far as a 401k, there's different considerations if you have a spouse or not, if you want to name the trust as the beneficiary, especially for IRAs. But we go through and do a letter. If you have this, this is how it needs to read. If you have this, you want to do this person first, then the trust. So we go through all of that with you.
But yeah, it doesn't automatically, just because you have a trust and you have an account at Schwab, it doesn't automatically go in there. You have to take steps to put it into the trust. And you can put some things in and not others.
Right. Clear as mud?
Yeah.
I know it's a lot, guys, and
That was awesome. Thank you guys so much. I really appreciate it.
no problem. And like I said, we have a little form, we're both the one for married. But if you're not married, just put one of your name, either husband or spouse, okay? And it goes through the process of you thinking, who would I want to act in this role and things like that? Because that's the first, like I said, the first thing is the brainstorming and the thinking about it, so that whenever you decide to do it, that you don't have to do you've taken the time, you've prayed about it, you've determined exactly what you feel is best for your assets. You can be that good steward.
Thank you.
So while she's turning that around, I'm gonna tell you, just while you're passing that around, I'm just gonna tell you the craziest, well, not the crazy, well, crazy. It's one of the craziest, I guess, fights I had in an estate. Guess what it was over? Guess what the grown brother and the grown sister were fighting over?
A TV.
Good guess, good guess. Weirder, anybody, weirder? Chandelier? Gallstones. A jar of gallstones. Now, I'm just gonna tell you, being the attorney I am, my client got the gallstones. But you know, I mean, the brother and the sister didn't trust each other so much that they brought pennies to our settlement and they dumped them on the table. And we honestly had to go one for you. One for you. And the brother would yell at me and go, and I wasn't representing him, he'd go, make yourself useful. And I'm like, okay. So we're doing pennies. And then the sister had this huge kind of wart on her face that my client, who he didn't know if he should look at it or not, very nice person. The brother had lost his leg, but didn't want to let the sister know before we met that he's lost his leg. So then we have pennies on the table, we're fighting over gallstones. The attorney and I are sitting here going, are you kidding me? And the brother keeps lifting up his stump and going, look, I have no leg! And he keeps like lifting it up over the table to shock his sister. Anyway, we settled.
And there's always a crazy train.
We settled and my client got the gallstones. So